Welcome to the 2008 Dewey Lecture. It's an honor and a pleasure to introduce one of the world's best and most important social theorists, Robert Goodin, to give the 2008 lecture. Let me tell you a few bare facts, if I may. Bob is an American who took his DPhil in politics from Oxford in 1975. He spent 10 years at the University of Essex before moving in the late 1980s to the Australian National University, where he is now joint professor of social and political theory and of philosophy in the Research School of Social Sciences. Bob's own writing spans a truly amazing range, and I can't think of anyone offhand, present company excluded, who shows the same kind of quality and quantity of work. To give you a flavor, he has written the best book by far on the ethical issues raised by prohibitions on smoking. He has written the best book by far on green political theory, on how to understand environmentalism in a broader social context as a kind of theory. And I commend to all of you his amazing book, Green Political Theory. He has written the best book by far on why welfare exists and why it's important to protect vulnerable people. Not only that, he has produced the best empirical work by far on the welfare state. I haven't even mentioned his foundational contributions involving utilitarianism and deliberative democracy, nor have I said a word yet, I'm about to, about his fascinating and impassioned work on terrorism. All this is about a glimpse at his contributions in terms of his own research, but those contributions are themselves only a part of his contribution to understanding of economics, politics, philosophy, law, and more. He is the founder of what may well be, probably is, the leading journal in political philosophy, unimaginatively named the Journal of Political Philosophy. He is the editor of numerous reference works and volumes, including a companion to contemporary political philosophy and the new Handbook of Political Science. He is currently, and condolences to him for this, the general editor of an 11-volume series of Oxford Handbooks of Political Science for Oxford University Press. He is himself editing 2 volumes of that series. His official service extends well beyond these contributions. He was the program chair of the 1994 World Congress of the International Political Science Association in Berlin, and he has done much more in that vein. These are more mere facts, but they're enough to suggest what everyone knows, which is that Bob has not only done extraordinary work in his own right, but he also brings people together and makes them a lot better. University of Chicago English professor Wayne Booth has a conception of the implied author, an illuminating idea which suggests that when we're thinking about works in multiple fields, we might think about the character of the author that is implied by the writing. Bob has an implied author who is engaged, committed, generous, fair, funny, never contemptuous, alert to human foibles, never putting himself above the reader. Many of our best implied authors are a little better than their actual selves. In this case, the implied author is the man himself. For someone of this sort, to the 2008 Dewey Lecture, we need a sports metaphor. And I was tempted, and still am, to start and end with Magic Johnson. Someone who is a terrific scorer, a strong defender, an amazing rebounder, and as good as anything at passing. But the better analogy is LeBron James, a better scorer than Magic Johnson, an even more joyful passer, certainly a stronger defender, and a better rebounder. Torn between Magic Johnson and LeBron James, I did a little research and found a study of LeBron James that actually had a section called The Future, and here are the key words. LeBron James continues to best his own records each season. His performance shows a mature player with leadership and extraordinary ability. He will be exciting to watch for years to come. It is an honor and a pleasure to introduce my friend, the LeBron James of academic life, this year's 2008 Dewey lecturer, Robert Goodin.
Should just go home, really, shouldn't I? It is an unusual experience for a short guy to be compared to a basketball player, so I thank you for that, Cass, and many other kind words. It's a great pleasure to be given this honor of being asked to give today's lecture, not least because I've been regarding this university as my second home. You know, I grew up next door for the best part of 25, 30 years now, coming back every 2 or 3 years. So it's an especially nice personal touch to be honored by this university in this way. But of course, it's an enormous professional honor to be asked to give the Dewey lecture. As Cass said when inviting me to do this, yeah, you know, this is a lecture that's been given by Rawls and Dworkin and Sen and Rorty and not too many others. You know, not to put any pressure on or anything. Well, you know, I'm not Rawls. Among other things, I'm not dead. But I'll do my best. I'm also not a lawyer, so, you know, take pity for that. But I was told it's a law and philosophy lecture, so scratching around for some appropriate topic touching on the law that I might talk about, I told Cass, oh yeah, well maybe I can talk about legal moralism. And from across the Pacific, one could hear the groan go up, you know, oh God, not that again. But Cass is a tolerant soul, and so he said, oh well, if you think you got anything new to say, by all means carry on. Hope I have, and you all be the judge of that. Legal moralism is the doctrine that law should track morality, and a whole lot of high-minded defenses of that doctrine have been offered over the years. The classic high-minded defense says that morality takes priority. The boldest version says the natural lawyers claim that morality is literally constitutive of legality. Divine commands in the old days, or moral imperatives of a more secular sort nowadays, are what makes law law. It's the job of the legislature simply to write those into the statute books, and when they cock up from time to time and don't succeed in that, then it just ain't law. Or a more modest version of that says that maybe morality is not constitutive of law, but anyway, it's a critical standard for assessing laws. Moral considerations are the ultimate right makers and wrong makers in the universe. It's the job of legislators to try to abide by them, or anyway not contradict them when writing the statutes. When they get it wrong, as inevitably they sometimes do, and they write something else into the statute book, well, it's still law, but it's bad law, according to the critical standards of morality that stand above the law. Well, those are fancy, highfalutin arguments for legal moralism. Take no stand on whether they're correct or not. I just want to bracket those. That's not what I'm doing today. What I'm doing today is much more low-minded, much less lofty than that. I want to talk about a much more pragmatic question. I mean, somebody mentioned Dewey. Yeah? A more pragmatic question is simply, how can we know what the law requires of us? Various answers are possible, but the most plausible, at least for a central branch of the law, is, to my mind, that we should write the laws in such a way as the laws track broad moral principles. And in that way, we're given best epistemic access to what the law really is. So, ignorantia juris non excusat. I'm not a lawyer, my Latin's bad, sorry. Ignorance of the law is no excuse. So we're told by virtually every legal code from Roman times forward. But why on earth not? I went across to the law library when I got this job, and I measured up how many yards are devoted to the US Code. By my crass counts, something like 364 bound volumes of the suckers sitting over there. How am I supposed to know what's in all that? Add to it the state laws. I had a friend go count burned statutes over next door in Indiana. 43 volumes of that. Add on all the city and municipal and county codes. I wouldn't even know where to look for those, much less count them. Throw on top of that all the sort of administrative rulings of various dozens federal and state and municipal agencies. No one can possibly know all the laws that apply to them. Ignorance of the law is, to some greater or lesser extent, simply inevitable. Now, of course, there are plenty of pragmatic reasons for insisting that ignorance of the law is no excuse nonetheless. One of them is in a delightful little 17th century tract by John Selden called Table Talk. Ignorance of the law excuses no man, not that all men know all the law, but because 'tis an excuse every man will plead, and no man can tell how to confute him. In consequence, 19th century jurisprudent John Austin adds the courts would be hopelessly congested if they had to explore all the claims that would inevitably be lodged if ignorance were accepted as an excuse. And furthermore, as Holmes said in finally nailing the point, admitting that excuse would perversely provide people with an excuse to avoid finding out what the law says. So, plenty of pragmatic reasons to pretend the law is no excuse, for even to hold to that doctrine, maybe. Further evidence that it is just those pragmatic reasons underlying the doctrine, though, is found in the fact that in practice, and notwithstanding that principle, ignorance of the law is often taken to excuse conduct contrary to the law. That happens, I am told, for example, in cases involving a regulation rather than a statute, or an omission rather than an action, or where the accused has relied on authoritative, but as it happens, misguided information on what the law is, or where the subject matter is unlikely to have been regulated by a law, or where the statute doesn't serve any important purpose. In all those sort of cases, I'm told it often happens that you can get by with the claim that, well, I was ignorant of the law. Of course, we don't generally tell people that ignorance of the law will probably be excused in such cases. Instead, for the pragmatic reasons we were just talking about, we let them think ahead of time anyway that ignorance is no excuse. From the point of view of natural justice, it's only right that illegal acts be excused when people did not and could not know the law at the time they acted. It might be similarly good from the perspective of natural justice that illegalities be excused where people had no reason to suppose there might be a law on the matter, the details of which they really should have ascertained. But as that other Austin, J.L. Austin, the mid-past century philosopher said, excuses, they have a way of getting you out of the fire and into the frying pan. Such circumstances obtaining really constitute bad news from the point of view of the social function of law. If people have no reason to suppose there might be a law on the matter, then their conduct can hardly be guided by that law. The law then fails to fulfill its central social function to be action guiding. Well, I take it as axiomatic that the law is supposed to be action guiding, and also that it's supposed to guide action relatively automatically. That is to say, people ought by and large be able to determine and apply the law for themselves without constant interpretation and constant enforcement by courts and constables. Laws that require constant interpretation and enforcement may still perform some useful social function, but they serve that function at considerably more social cost than ones that are more nearly self-interpreting and self-enforcing. In his attempt at teasing out the minimal content of natural law, Herbert Hart invites us to consider what is in fact involved in any method of social control, rules of games or rules of law either, which consist primarily of general standards of conduct communicated to classes of persons who are expected to understand and conform to the rules without much further official direction. If social control of this sort is to function, the rules must satisfy certain conditions, and Hart goes on to elaborate a few of those. They must be intelligible, they must not be retrospective, and so on. But those familiar propositions really just constitute the limiting cases. Of course, it's literally impossible for people to understand and conform to a rule that does not yet exist or that is literally unintelligible. But the method of social control that Hart has in mind does not merely require that it's possible for people to understand and conform to rules without a further official direction. It further requires that it actually be probable, likely, that they're going to do so. Now, in ordinary discussions of these topics, as best I can tell in the law, the emphasis falls heavily on those possibility conditions, the limiting conditions, especially on the requirement that laws have to be promulgated to be law. If it hasn't been promulgated, then ordinary citizens have no way of knowing what the law is and can't guide their actions by it. But suppose a law has been promulgated, but only in a minimal sort of way. I mean, it's been published in an official record, only a few copies of which have been printed. Or it's been announced from the steps of the courthouse, but in some court language that only a few people understand. It wouldn't be literally impossible for people to know what the law is then, but it's still pretty highly unlikely they're going to know what the law is. And a barely promulgated law of that sort fails to perform the social function of law to almost the same extent, and for exactly the same reason, as a law that's not promulgated at all. Notice also that maximizing promulgation is not necessarily the best way to maximize the extent to which people know what the law is. So imagine you provide every household with all those 364 volumes of the US Code, or digital access to the same. That might maximize promulgation, but doing that's not going to maximize the extent to which people really know what's in that 364 volumes. There's just too much of this stuff for people to wade through. Well, historically, going way back, the principal reason I assume that ignorance of the law was not accepted as an excuse was that the law was deemed to be something that everyone knows, or anyway, something that everyone could and should know. That first formulation, law is something that everyone knows, might have been true, almost analytically so, in primitive legal systems where customary law was the only kind of law there was. In a system of customary law, something counts as a legal requirement if and only if it corresponds to the customary practice of the people, and obviously people know their own customs. There's sort of second nature, as the saying goes. Well, that almost analytic guarantee that people know what the law is disappears as we move away from purely customary law and towards systems that include edicts and statutes and administrative orders and judicial precedents. At that point, the proposition that everyone actually knows what the law is becomes wildly implausible, and the emphasis shifts toward a very different proposition that everyone could and should know what the law requires. Lots of scorn has been heaped on that proposition over the years. John Austin was blistering on this point. That law might be knowable by all those who are bound by it, or that law ought be knowable by all those who are obliged to obey, is, I incline to think, true. That any actual system is so knowable, or that any actual system has ever been so knowable, is so notoriously and ridiculously false that I shall not occupy your time with the proof of the contrary. Dreadful prose crafts in the Victorians. More fun is a quick reply from Lord Mansfield, who said, "'Twould be very hard on the legal profession if the law were so certain that everybody knows it. Hard to make any money off it that way." Or another English jurist acidly remarked that everybody is presumed to know what the law is except His Majesty's judges, who have a court of appeals set over them to put them right. And of course, the idea that today's vast network of government controls and edicts and administrative orders and all that's known to everybody is more ludicrous than ever. But let's go back. Even in Roman times, the rule as to ignorantia juris did not apply to certain classes of individuals because it was considered that these individuals, by reason of status or condition, should not be expected to have knowledge of the law. Among people exempted in that way were people under 25, so half the room is safe from the looks of it. Women, soldiers, peasants, the mentally infirm. Significantly, though, they were exempt only in respect of the jus civile, not the jus gentium. The rationale was that while their condition or status may be such that they could not be expected to know the details of the particular jus civile, the jus gentium is knowable naturale ratione by everyone, whatever their status or condition. Now, Glanville Williams proposes that we resurrect that ancient practice and adapt it to the circumstances of the modern regulatory state. A distinction should be drawn, he says, between crimes resting on immemorial ideas of right and wrong, where it's the business of the citizen to know what he may legally do, and modern regulatory offenses, of which the citizen would not normally know unless there is something to put him on inquiry. Moreover, the principle of German jurisprudence could be adopted that the defendant is required to have exerted his conscience properly, making inquiry as to the law where a conscientious person should have reason to do so. Now, I agree with that old Roman principle and the principle of German jurisprudence that Glanville Williams commends on the basis of it. There are certain sorts of people and certain sorts of activity that are governed by very specific laws, the details of which the people concerned could and should be expected to ascertain for themselves. Here are two big classes, maybe there are more that you'll tell me about shortly. First is, there are certain rules of law, a lot of them, that are power-conferring rather than duty-imposing. Hart's examples are rules such as those prescribing the procedures, formalities, and conditions for making marriages, wills, or contracts. When you set about invoking the powers under law, writing a will that's going to hold up in courts, you must know that there is some law that you're trying to manipulate, and you should know that you need to check the details of that law in order to invoke it correctly and efficaciously. So that's one class. A second class, many rules of law are not wide scope applying to everybody in general, but rather narrow scope applying only to people in very specific roles. Lon Fuller agrees with my initial observation about the vast array of laws on the book. He says, any expectation the dutiful citizen will sit down and read them all is an absurdity, but Fuller thinks that that absurdity is mitigated by the fact that the great bulk of modern laws relate to specific forms of activity, such as carrying on particular professions or businesses. And it's therefore quite immaterial that those are not known to the average citizen. Anyone who's occupying a very special role, a very specific social role, could and should imagine that there might be specific legal powers and duties attaching to that role, and he could and should take steps to ascertain what exactly those might be. In the old Roman model, those cases seem to me to concern people who know, and surely should be expected to know that they need to know furthermore, the jus civile, the particular laws that apply to them, and the particular roles that govern the particular powers they're trying to invoke. I'm not going to be concerned with those people, and I'm not going to be concerned with them for two reasons. First, as I just said, given their special circumstances, they should be expected to know they have a need to know and go find out. Second, and more related to what I'm going to go on to say, the content of the law that governs such special situations is likely to be correspondingly special, and often enough somewhat arbitrary. There is no obviously correct way to write a will that's derivable from first principles. The exact form of words required to make a will efficacious around here is something you just have to go look up rather than surmise from first principles. So I'm not going to be worried about those sort of cases. My concern is going to be instead with a great bulk of people in general and how best to give them epistemic access to the content of wide-scope, duty-imposing rules under which they live. So wide scope means outside of any specific roles that give rise to those narrow scope of special responsibilities. Duty imposing means rules of law that are not power conferring, bracketing out those situations in which people are knowingly trying to manipulate the powers of the law. Epistemic access just means enabling them to know the content of the rules governing them. And my argument is going to be that laws tracking morality is the best practical means for giving people in general epistemic access to what wide-scope duty-imposing laws require of them. The classic case of wide-scope duty-imposing law is, of course, the criminal law. How do we know it's against the criminal law for us to do thus and such? Well, sometimes we have a friend who's just been sent down. Sometimes we read about the case in papers. But by and large, we simply surmise what a crime is at law from what we know about what is wrong morally. Indeed, reflecting upon the moral is our ordinary way of surmising the criminal. That's so obvious that it's often overlooked, I think. So here's a passage in Law and Fuller's Anatomy of the Law. Suppose, Fuller says, a citizen wants to know whether some act he proposes to do is criminal. We are assuming that the question arises in an area of conduct where the ordinary standards of moral behavior are an insufficient guide. And he goes on to tell a story about some newsstand owner who's wondering whether it's legal for him to open up on a public holiday or not. Now, for present purposes, forget about the newsstand owner and just go back to the bit that I was quoting. How could it be that a citizen is puzzled as to what the criminal law requires of him? Well, as Fuller says, we are assuming that the ordinary standards of moral behavior are an insufficient guide. But that's just to say what I'm here taking as my main point, that the ordinary way we find out what's criminal is to reflect upon what's moral. That's our first best recourse. And only when that's an insufficient guide, only when morality is silent or confused or unclear or contested, do we need to make further inquiries about what the criminal law actually requires of us. The criminal law, of course, is just the most dramatic example of wide-scope duty-imposing law. The same thing is true of, to a lesser extent anyway, of all other types of law of that sort. As dear old John Austin observed a century and a half ago, some laws are so obviously suggested by utility, that's his standard of morality, remember, that any person not insane would naturally surmise or guess their existence. And most men's knowledge of the law is mostly of this kind. They see a particular act would be mischievous, and they conclude that it must be prohibited. The conduct of 19 men out of 20 in 19 cases out of 20 is rather guided by surmise as to law rather than knowledge of it. Smart dude, Austin. Got that one in one, I reckon. For people to have good epistemic access to the content of the law, what's needed are at least two things. First, they need a way to intuit without detailed investigation what the law is for the most common and important cases of their conduct. And secondly, and equally important, they need a way to intuit when their intuitions are unreliable guides, and hence they need to investigate further what the law actually is by checking the big book. I'm going to suggest that letting wide-scope duty-imposing law track morality is a good way of accomplishing both tasks. It's easy enough to see that's true as regards the first desideratum, I think. If law tracks morality in cases where moral sentiments are univocal and strong, then people don't need to look up the law in a big book. They need simply to ask themselves what should be the law in this matter and assume that that's what the law is on that matter. Furthermore, you get common knowledge that way. I know that you know that I know that you know what the law is, and so on and so forth. After all, it is, as Hart says, an essential feature of any moral standard or rule that is regarded as something of great importance to maintain. This is manifested, among other things, in the serious forms of social pressure exerted not only to obtain conformity in individual cases, but also to secure that moral standards are taught or communicated as a matter of course to all in society. So by tracking morality, law can piggyback on all that apparatus that's already in place for promulgating the moral code. The second desideratum is that there should be a way for people to intuit when their intuitions are likely to be unreliable as regards the content of the law. I've already discussed a couple of those cases. Remember the case where we're dealing with some power-conferring rules of law, or the case with narrow-scope rules of law that apply to people in very specific roles. I want to move beyond that now to cases where people need to intuit when their intuitions are likely not to be reliable, even as regards duty-imposing wide-scope rules of law like the criminal code. Well, here's one way. Suppose law tracks morality, but suppose morality is and is known to be unclear or contested on the point in question. If there's no clear moral ruling in the situation, then neither can there be any strong inference from morality to what the legal rule is likely to be. Just as with someone occupying one of those special roles or trying to revoke special powers like writing a will, in this case, you just know you've got to go back and check what's actually written on the statute book. So does this just amount to a suggestion that we revert to customary law? Well, it does if the morality you propose writing into the legal code is purely positive morality, the conventional rules of society as you find it. It does not if the morality you write into the law is critical normative morality, what is really right and good independently of what people around here happen to believe it to be. The epistemic argument that I've been developing most naturally seems to incline toward writing purely positive morality rather than critical normative morality into the law. After all, it's the positive morality to which everyone in the community has most immediate epistemic access. But here, Hart's question pulls us up short. Does the morality with which the law must conform really mean the accepted morality of the group whose law it is, even though this may rest on superstition, or may withhold its benefits and protections from slaves or subject classes? The question makes me uncomfortable. One response would be to say that the different arguments for legal moralism simply pull in different directions. The pragmatics of maximizing epistemic access to the law would indeed recommend letting law track positive morality, however wicked. There would be epistemic costs in deviating from that. But from the perspective of the more high-minded forms of legal moralism, those epistemic costs would be well worth bearing. High-minded legal moralists would insist that law ought track the requirements of true normative morality, however unfamiliar people might find them. Those laws then, of course, would have to be promulgated and well publicized. People there could not easily intuit them, but so much the better, the high-minded legal moralist might say. Then the law would be giving people a moral education and no bad thing. This first response might go on to say that while perhaps high-minded consideration should trump lowly epistemic ones in cases of conflict, such cases of conflict won't necessarily arise all that often. Much more often than not, we can allow law to track positive morality without any great moral cost, and in so doing will greatly enhance epistemic access to the law, thereby helping law to do what it's supposed to do, which is guide our conduct. Well, I think that probably is the right response, but let me add a second response that tips the scales of that trade-off a little more toward critical normative morality for purely epistemic reasons. And the thought here is just this, that letting law track critical normative morality rather than purely positive morality, should also be preferred for the same reason the common law is to be preferred to customary law. And the common law is really just the customary law among judges, but what makes the customary law among judges superior to the customary law among the folk is that the judges feel obliged to bring their practice under some principles, to treat like cases alike in different cases, differently only in proportion to their differences along some principled dimension. Of course, the principles that the judges elaborate quickly become quite complex, and there's no chance that any ordinary punter is going to know everything in the 30 volumes of the Restatement of the Laws any more than there is that he's going to know everything in the 364 volumes of the U.S. Code. If citizens want to surmise the law for themselves, they need something far simpler and more straightforward than the plethora of principles that judges have written into common law. Still, it's easier to work out common law from first principles than it is to work out statutory law from first principles. There's no telling what those legislators might have gotten up to some late night sitting toward the end of the session. In similar fashion, it's easier to work out normative morality from first principles than it is to work out positive morality from first principles. The customary moral practices of any particular place have a long history of assorted accretions. There's no rhyme or reason to most of them. Like statutory law, you just have to learn them off by heart. And if there are gaps in your knowledge of them, then there's little you can do to fill in the missing bits by adducing from what you know about the rest of the customary moral practices. Critical normative morality, by contrast, is arguably anyway organized around a small set of fundamental principles, precisely so people can work out for themselves what morality requires of them. After all, there are no moral courts that issue authorized interpretations of the moral code. Critical normative morality must be structured in such a way that, by and large, people are able to work out its edicts for themselves. Now, if we think that law should track morality purely for the pragmatic reason that in that way we give citizens better epistemic access to the content of the law, then it's those simpler and more readily accessible principles of critical normative morality that it should track. Purely positive morality is less predictable, less straightforwardly derivable from first principles. It's less epistemically accessible to people in consequence, and less epistemically suitable as a basis for law for that reason. So far, I've been mounting a case for law, at least in its wide scope, duty-imposing aspects, to track morality and to do so, and to track critical normative morality rather than purely positive morality. And the reasons I've offered are purely pragmatic ones. That's the best way to give people in general epistemic access to the content of the law that's supposed to guide their conduct. That's an important pragmatic consideration, but of course there may be other pragmatic considerations, there may be other principled considerations weighing heavily in the opposite direction. So the reasons I've been giving you are just pro tanto reasons, not conclusive reasons for letting law track critical normative morality in that way. To say that law should track morality is, strictly speaking, to suggest that the law should prescribe or proscribe phi if and only if morality, critical normative morality, prescribes or proscribes phi. The epistemic considerations that I've been giving you so far really only give you grounds for the only if bit of that biconditional. They provide epistemic grounds for thinking that law, in its wide scope duty-imposing aspects anyway, should instantiate only morality. The question I want to raise in closing is whether anything I've said implies that law should instantiate all of morality, even just in its critical normative rather than positive form. Now, of course, that's the question that was more at the heart of the old-fashioned conventional debate over the legal enforcement of morality. What Hart and Devlin were arguing about, after all, is whether homosexuality should be illegal just because, as both assumed, it was immoral. Now, that judgment of conventional morality of the 1950s that both Hart and Devlin shared itself ought to be brought subject to some critical normative moral scrutiny and may not withstand that. Let's bracket that issue. Beyond that, notice that that was in itself a debate within critical normative morality, whether or not there should be some space for people to engage in purely private regarding acts, however immoral, without bringing the full force of the criminal law to bear upon them. The fact that an act is or may be morally wrong is sufficient to put the general public epistemically on notice that an act might be legally prohibited. What it tells people is, you better go check. Right? So my conclusion is that law need not enact every aspect of critical normative morality. There might be good reasons for leaving some of that off the statute book. But the fact that the act is at least arguably immoral gives everyone fair notice that they'd better go check the law for themselves. And telling everyone, think twice before behaving in ways that are arguably immoral. Think twice, go check. That's not bad advice. Thank you.
Many thanks to Mr. James for scoring so many points. What we will now do is take questions till about 5:20, at which point there'll be a reception. And Martha has the first question.
Yeah, I wanted to ask you about a Rawlsian distinction to see if you would accept this as a supplement to the argument. Now, there's a part of morality that all citizens, let's suppose, were given their different religious doctrines or secular doctrines, can be expected to share. And then there are other parts that citizens are aware or should be aware they can't expect other citizens to share. So isn't it this first part that we should be thinking of when we think about law? And shouldn't we be encouraging citizens to be aware of that distinction? And let's say, suppose their religion tells them they can't eat pork, they should not expect to look that up in the statute books. They should be well aware that because that isn't something for which they can give public reasons to other citizens, they shouldn't expect that there would be a law forbidding that for all. So would you accept that as an extension or a kind of supplement to your position?
Good. I mean, for sure you want to enact those first class of laws. At this point, I'm going to wobble a bit between customary law, conventional morality, and critical normative morality. As regards the second class of laws, you shouldn't expect them, you shouldn't think you have a right to demand that they be on the law book, for sure. You shouldn't expect as a prediction that they will necessarily be on the law book. But if you know you live in a community that is split between these fundamental moral codes, you have a reason, you're epistemically on notice that might well be that because I live in a mixed society like this, there are going to be some special provisions about pork, and if I'm a restaurateur for sure, but even if I'm just an ordinary citizen, might have reason to go check and make sure what the law is on the books.
But see, I guess what I'm saying is when you think about what critical normative morality ought to be, that's pertinent to law, we ought to be very careful to exclude from that the things around which there are reasonable disagreements, which actually would include the morality of homosexual conduct. And I think it's actually very interesting that Devlin didn't actually say we should avoid it just because it was immoral. He had actually much more consequentialist argument having to do with people refusing to fight in wars because they were so swept up in degeneracy and so on. But anyhow, suppose all we could say against it was that the vast majority of religious doctrines, and maybe even secular ones in our society, think it immoral. Shouldn't critical normative morality say, wait a minute, is that the sort of thing for which we can give public reasons? And if the answer to that is no, well then we better leave it out of law, no matter how majoritarian the sentiment in favor of it would be.
Yeah, remember my problem is, it's not what we should write into the law, but the epistemic access issue. And so, looking at it from the citizen's point of view, what's likely to be law there? You surely ought expect that anything that withstands the first Rawls test, that really withstands critical normative morality, you expect that's going to be in there. Almost bet your bottom dollar on that. Be real surprised if it wasn't. The other, nobody would have any good claims that that should be written into the law, but you ought just be a little bit wary from the citizen's point of view, I guess, is all I'm saying. It's not I'm providing an argument that it should be in the law, but just fair warning to the citizen it might be, and that, from the citizen's point of view rather than the legislator's point of view, seems to me the right answer.
I think Cass has a question.
No, well, why don't we have Cass then?
Cass, your turn. This follows up on Mark's question. I didn't quite get the jump from customary law to critical normative morality insofar as you're speaking epistemically. Let me spell that out a little bit. If you have a conception of the theory of the representative, where the representative is closely tracking citizen behavior, then the representative would just be reflecting maybe conventional morality, and the epistemic problem would be solved. But suppose you had a conception of the representative's role that's more deliberative and critical, as I think you do. So the representative might think, well, what people think morality requires isn't quite right, and I have a critical approach which would require me to not to punish things, Martha's point, that conventional morality punishes, but also to punish some things that conventional morality is okay with, maybe hate crimes or something. And then on that account, it might be epistemically demanding to require the ordinary citizen to try to follow the critical morality of the representative. But oughtn't we to say, kind of, so be it? That it's, so I'm not sure what the pro tanto argument is doing. If you are going the critical route, which I guess you are, I don't see why how the argument goes through.
I think I'm going to play a moral schizophrenia card on you here. And the argument is this. If your representative were just writing your prejudices into the statute book, and if everybody's prejudices were the same, then of course you'd have immediate and epistemic access to that. But people have two selves, the moral schizophrenia card. People know what their blind prejudices are, and standing back, in Sunday school or something, they know, yeah, those are blind prejudices. I really shouldn't have those. They're really naughty, really nasty. Throw in the sort of mixed community. Different people have different prejudices. It's the job of the legislator to speak to my higher self, not my baser self. It's the job of the legislator to speak for all of us rather than particularly bigoted sections of the community or bigoted in different directions across different sections of the community. It's going to write in my Sunday school morality rather than my day-to-day prejudices. Do I have epistemic access to my Sunday school morality? Well, just change hats. Of course you do. Do I have better epistemic access to my Sunday school morality than I do to the average base prejudice morality across the whole diverse population? Probably. That's my answer.
Doesn't that identify Sunday school morality with critical normative morality?
Yeah. That was exactly the identity. Yeah.
Wouldn't that be a surprise, wouldn't it? If what critical normative morality required is actually Sunday school morality of what? The United States 2007?
I'd rather leave the indexical off, of course. Yeah, the thought is that we paid philosophers like to think we do it better, but the fundamental principles of morality, are fairly simple, and at least in baseline cases, people can do it reasonably well for themselves.
I like
I like all that. Basically, three norms: two we like and one we're uneasy about. The one we like reciprocity, and we like the one about alcohol. We're never quite sure as a homosexuality example because what we're supposed to do with this ubiquitous third evolutionary norm and discuss. I want to practice that, however, because I think that there's a peculiar way in which the account of Goodin doesn't quite handle the epistemic problem the way in which we in fact handle it. Because anyone who's trying to think about how information gets transferred doesn't rely just on common morality, doesn't rely on the statute book. There are all sorts of intermediate organizations realizations that are always brought to bear in the way in which this goes. So if you look at the statute book, it's not as though there's 42 volumes that relates to me, but there may be one volume that relates to me as an operator of a restaurant or as a point one and that and so forth. And what happens is, I know I'm in that kind of business. I run a trade association. They hand the bulletins out. And all of a sudden, things that have no normative content, like when you have to file for your permits and so forth, become handled by that. Now, isn't that indicate that, now I'm going to go speak against interest, that once we have systems like this, you can actually run a somewhat larger state with more complicated administrative situations than the very simple account of epistemic knowledge that you gave, namely one in which it's either sort of blazoned on everybody's doorstep or as part of common morality. And should some effort to try to figure out how political morality works, takes into account these alternative and commonly resorted to modes of information dissemination.
Sure, and those are the narrow scope duties I was talking about. I mean, this is how to write a will. This is how to run a restaurant. When you're in a special role doing something that's likely to be governed by statutes, the details of which are inevitably arbitrary at the margins. You got to go look it up. I mean, that's absolutely right, exactly as you say. That's how we get a big and complex society, by partitioning off little bits of the statute. But the residual is. Oh, it's important. No, I'm sorry. I'm a student of Purple Heart. I know it's important. I know it's important. But I have a sneaking suspicion that criminal law is too. And that sort of answer. Who are the intermediary associations that tell us what the criminal law
Well, I mean, in many areas, for example, how you run a restaurant, there are lots of areas of statutory fines, which have statutory criminal offenses and so forth. And at that point, this mechanism becomes there. There is, at least in American law, a peculiar doctrine that certain kinds of things for which ordinary citizens have to do, for which there be non-expectations, you do imply the ignorante of your assistance. Famous case involving a situation where you had to register when you went to the city of Los Angeles in 1956. And some poor guy who was a former criminal didn't register, and the question is whether he would be punished. And they actually gave a due process kind of exception because they said, who would expect that kind of a registration to take place? But I think actually expectations today with use in molestation laws and so forth may well have switched away from that earlier civility. I think now we basically expect former criminals to go to a website and figure out former criminals' obligations to report.
Yeah, that's okay, but here I'm going to be even more lawyer than lawyer. Okay, I'm just going to code the criminal, the ex-con, the guy with a record, as like a restaurant owner. He's in a special role. He should know that he's got special things that are going to apply to him, and he better go find out what they are. So when I'm talking about the criminal law, I'm doing it in a fairly loose way as law that applies to citizens in general, rather than in even that particular ex-crim role.
The expectation used to be reversed. 50 years ago, the guy won. Today.
Yeah.
I was wondering if you might have some thoughts on the question from another direction, which is, instead of asking if ignorance of the law is an excuse, wondering if knowledge of the law creates an entitlement. So I'm a proceduralist, and this talk makes me think of things like forum shopping. So in other words, instead of using ignorance of the law as a sort of epistemic shield, using knowledge of the law as a sword, and deciding to go and litigate in a certain jurisdiction because the laws there are more advantageous. Or on the more regulatory side, deciding, for example, to open your factory in a country where the wage laws and environmental laws are much less stringent than in your own jurisdiction. And whether that specific knowledge of what the law is might give you some sort of an entitlement to be ignorant in a way of the moral questions behind it. So in other words, as long as I dot all my I's and cross all my T's, have I somehow obliterated any obligation to look further and engage in the sort of moral inquiry that I can find in regulations.
That's nasty, but probably true. I'm afraid you're probably right on that. I guess a slogan that I'd be tempted to play with, and I'm not sure whether I could get anywhere with it, would be that knowledge of the law is a burden and imposes obligations. Just flip the ignorance of the law thing on its end. And so, bad news for you guys. All this time you're spending learning the law, you're incurring all these massive obligations. And indeed, I suppose, you go to court. I mean, you say, excuse me, my lord, I didn't know. And he says, what do you do for a living? You say, I'm a lawyer. Bad luck. So, knowledge of the law is a burden. Is another slogan.
Richard? I wanted to follow up on Cass's question about the gap between the critical morality and positive morality. And I guess, am I right in assuming that you just don't think there's that much of a gap, really? So, the problematic example is when, as Cass says, the critical normative morality would seem to prohibit something that the positive morality doesn't. And I wanted to mention a common area would be violence in certain contexts, like domestic violence, where norms of revenge permit violence in certain cases, but a critical normative morality wouldn't. And maybe that's what you meant by Sunday school, that in some calmer moment people know that's true. But I guess I'm very skeptical about that. I think people very deeply believe that it's not just that they do it in their coarser moments, but that they actually think that's right. You're entitled to use violence in that case. Another example might be maybe critical normative morality should prohibit the killing of animals or things that we kill animals for in ways that would be a great surprise to a great many people. So I guess the way to ask this question is what do you, if there is such a gap, I mean, do you think that the law ought to then give some sort of defense to people who genuinely are surprised because their actual morality doesn't put them on notice as to the fact that the law might regulate it? And another way to posit that example would be, what about someone who comes from another culture and is an immigrant to a new community? Are they just automatically on notice for everything because they should sit down and read the code book because they might be surprised? Or can we, if in fact their critical and positive morality is sufficiently different, then they might actually be quite surprised?
Yes, well, I mean, on the latter, I think the answer is both morally and legally clear. I mean, I've spent most of my working life as an object rather than a subject of the crown. I've lived somewhere I don't belong. So, I've known all along that I was on notice that, things are weird around here and I better go find out before I do anything dodgy. On the sort of wife abuse issue and things like that, or, animal abuse, the structure of my argument requires it to be the case, and it's an empirical claim whether or not it is the case, that people do have epistemic access to what critical morality would require, and at least as good epistemic access as they do to what customary morality requires, maybe a little bit better. And if that's not the case, then my argument is stuffed. I mean, that's just rests on that empirical proposition. And I can well imagine cases in which that's just not true. So, I mean, imagine the animal liberation argument before we realized the pain caused animals, before we had the scientists doing the metrics that showed the sort of spikes when you jab needles in them and things. If you just in a timeless critical morality framework, it was always wrong whether or not we knew it was wrong to jab the needles into them, but only now have we epistemic access to the fact that it actually is causing pain, so we shouldn't do it. In cases where we just don't know, where we don't have any possibility of epistemic access to what critical morality really requires, then obviously this epistemic argument for writing the legal code in a way that tracks that doesn't make sense. And to that extent, Cass's indexical of critical morality today is right. I mean, what we know about critical morality changes over time if critical morality itself doesn't. But by and large, I think the Sunday school story, is broadly right, that people, even when it's generally accepted you can beat your wife, all the boys joke about it down in the pub, it's wrong. It's wrong. You know that everybody is going to laugh about it, you're going to get by with it, it's wrong. And that's a bold empirical assumption.
I was wondering if you could say something about whether your account cuts wood against certain kinds of paternalistic laws, say laws or that sort of thing. I'm not sure what ordinary rallies are about this kind of thing. It's certainly not fair, unless you can be fair or utilitarian, in which case you can say, well, of course, why not make an act less utility? But that seems like the kind of thing where we have a lot of dispute as to whether utilitarianism is the right way to go for morality. And so I was having a hard time figuring out that kind of case or other kind of cases where there's much out that you're
Yeah, well, I mean, of course, suicide is not something that Kant had much time for either, so it's not just utilitarianism. My hunch is that that's a hard one for the same reason that self-regarding acts, homosexuality and all that are hard ones, which is to say we have a tension within critical morality of doing the right thing on the one side and on the other side giving people space to lead their lives in a way of their choosing, and there's a good reason within critical morality for doing that. The first pushes you in favor of paternalism, the second pushes you away from paternalism, and I think that's just a tension within critical morality probably. So when I say law should track critical morality for epistemic reasons, critical morality is providing a two-headed arrow, and it's no guidance, and so we do throw up our hands. So I think that's the diagnosis I'd offer of why it's a head scratcher.
A critic in Richard Epstein's general vein would also indicate or suggest that there's another vehicle for disseminating information, which is, say, low or zero penalties for personal discretion.
I mean, my only objection to that, of a principled sort, I guess, it was always my objection to the sort of rule in universities that you only could hang people on their second plagiarism offense. I mean, it's just an invitation to plagiarize once. Do you really want to give them a bye the first time they commit murder? Do you really? I mean, so that particular plank anyway seems to me not altogether comfortable. I mean, you want to say, look, I mean, there are some things we just should be able to assume that better state promulgation of the laws, better efforts to get the laws out there. Well, I guess you could boil down the 364 volumes of the U.S. Code, or even, bracketing off the bits that are role-specific, the 25 volumes of the U.S. Code. I guess you could boil it down to a pocketbook of some sort, just like the driving code, is that thick on the statute books, but is, 15 pages in the driver's license bureau when you go down and get your driver's license. I mean, maybe you could have a sort of pocketbook version, but boiling 20 volumes down into a pocketbook version doesn't sound like it's going to fit into a pocket from my point of view. So I'm a little bit skeptical of whether that strategy is going to work all that well without your, give them a bye the first time, which seems to me to have other costs.
I have a question on your theory. It works very well on the is this a crime, is this not a crime. What about the variable punishment angle? We don't punish all crimes directly, and I don't see a way any sort of empirical morality or any other system will be able to determine exactly how much a particular crime is punished. If that is something which people always have to look at, how is that any different from the current system aside from what you choose to punish and what you don't?
Oh, no, I mean, I think critical morality comes graded, doesn't it? I mean, there are some things that are, really bad according to critical. Yeah, I mean, unless you're, some stupid Kantian, but, I mean, there are smart Kantians, I hasten to add, it's not just, bright line, all equally bad on that side, all equally permissible on that side. And if critical morality comes graded, I mean, you can't read the exact number of dollars or number of years punishment off it, but you get some sort of scalar from critical morality as to how bad the punishment's likely to be for an act, depending on how bad critical morality says it is.
Going back to Professor Samuel's point for a moment, my worry is for people who the instinct of go look it up hasn't been developed by virtue of how they grow up. So, for example, you said, the first time you think about is it moral or not, and then, if that brings question, then you go look it up. But I think people who want to use ignorance of the law as an excuse would argue or say, I grew up in an area that we don't have libraries readily available, or it's not stocked as well as other areas, and things like, even if that's so, I never knew I could just go look it up. I mean, so wouldn't then saying, okay, well, this is your first time violating the act, now you're on notice for it, because the video crimes of murder and stealing and things like that wouldn't necessarily, that would be done away with the moral intuition part of it. But I think you're going to have this situation come up in ambiguous cases where people aren't, I haven't seen people know much like that. So wouldn't then the violation of that, those sort of crimes, say, now you're on notice for that, they'll go back to their communities and say, look, I just got caught for doing this by the way, so it's a crime. And that was help spread information in areas where law school libraries or things like that aren't readily available.
Yeah, sure. I mean, if you'll give me, main proposition, which is, where critical normative morality gives a really clear guidance, then, you ought just think what critical morality says, assume that's the law, done deal. In these other areas where, where I'm saying, look, it's contested, it's unclear, go look it up, and you're saying, where? I mean, where the hell do I find this? I mean, as I said, city statutes, I don't know where to find those, right? And I've got a decent education. Then maybe that, for those lesser things, maybe that, give them one warning and then come down on them is the right answer. But that sort of assumes that the things like that are of lesser moral importance. And so we can afford to say, well, this first time it's forgiven, but just go tell all your friends not to do that.
I just wanted to question just about your power conferring categories, because as you said, evidently power conferring something not being so obvious. So I just thought about the idea of proper. Something that you could see as the state conferring the power to do, or maybe someone in that citizen just thinks is inherent. And I think about doctrines such as adverse possession to a property unbeknownst to you. And it just made me wonder whether descriptively you have a situation where it's actually true that some things are obviously power conferring, some things aren't. Maybe will might also be something that I just think I have the power to do. I don't think to consult an attorney. And then normatively, it struck me there might be sort of a feedback loop, right? You're making assumptions about what is power conferring, obviously power conferring, whereas that very question could itself be part of the normative framework such that it's not, I have to ask, there's sort of a meta question about when I have to actually decide something is power conferring such that I know to consult with legal authority.
Not sure I got the very last bit, but occupying property, you might not think you're exercising legal powers. Claiming property, or claiming the right to exclusive enjoyment of property, when you're headed for the courtroom, you think, aha, surely, at that point. Or when you call the cop to get this guy off, surely you think, you may not phrase it this way, but I mean, you must know that you're trying to exercise legal powers at that point, don't you?
Right, so that's sort of my point, though. When you're drafting a contract, of course, you're right, if later you then have to go to court to litigate the contract, you'll know that you needed to, in the analogy is call the cops or call the court, but at the time you're drafting the will or writing the contract, you might not be thinking that way. You're right, almost anything could lead to a situation where you need legal intervention, but there's some earlier states where the law is kind of implicitly there, but citizens might not be thinking that way at that point.
Don't you think? I mean, here we're in anthropology, and yours is as good as mine. But I mean, don't you think that most little old ladies, however schooled in the law or not they may be, would know the difference between writing their daughter a letter saying, "I want you to have my wedding ring," and writing something that's going to stand up in court that will give her the wedding ring? I mean, wouldn't most people sort of think different, I mean, wouldn't it? I mean,
I guess, to me it's an empirical
yeah,
question.
yeah,
I don't know if it's possible.
yeah.
I was wondering, to what degree does deriving the epistemic access from morality, to what degree does that rely on there being truth or falsity about morality? And then, in the case of moral skepticism, do you have to rely on morality?
Yep, you got me dead right. There are truths of morality, thank you very much. Skeptics are wrong. If skeptics were right, all you'd be left with is customary morality. But, I mean, I guess you could then tell an analogous argument about customary morality.
No, I'm with you on that. I'm not a skeptic. I didn't know if you had an answer.
No, I mean, it's a table thumper. I mean, yeah.
We have time for one more question.
You talk about the parallelism between law and morality. There are a couple of cases, usually involving morals and rescue type situations, where many judges have happened to the opposite direction. I'm curious what your reaction is. So, there's the standard Good Samaritan case, and the usual opinion says there's no duty to rescue a stranger, however heinous and immoral it is, by judges who believe it's both heinous and immoral. And the question is whether or not we ought to put that rule over, given the fact that it epistemically tracks a very strong moral situation. And the other situation is somebody does a good deed to you without any benefit of promise, and there's no formal obligation to pay. The question is, most people say it's immoral not to, particularly after you make a promise to do so. But in both situations, with or without promise, the hornbook law is generally you don't have to pay, notwithstanding the fact that it's immoral. Should we regard these as regrettable outposts of the legal system, or do they involve some institutional concerns that my account hasn't taken into?
I think this is where I ended, and I sort of said, well, look, there might be all sorts of reasons. Sorry, this is the make it illegal if and only if it's immoral. I've given you arguments for the only if, but not for the if. Okay, and your counterexamples are if counterexamples. And so this is, you would need to press and ask questions about, well, why shouldn't we make it illegal as well? But, I think that's covered in that caveat. I mean, I assume that the reason that Good Samaritan laws, where there are no Good Samaritan laws, where the judges say, well, they're rotten blighters, but damn it, it's not illegal. They say it's not illegal because it would be an unbearable burden for anybody, psychologically or maybe materially, to be under an obligation to help any old buddy that they come across who is in a bad way, especially if they're in circumstances where they're likely to come across a lot of people who are in a bad way, and blah, blah.
Both conventional and critical morality dictate that we thank Robert Goodin